congrats again on passing the bar this past year. This is a really exciting time for you. My name is Rob Dean. I practice law in the city of Roanoke, and it was 3 years ago that I was in your seat. So I'll tell you, I drive past the Civic Center on my way to work every day, and just a kind of cold chill washes over me when I see that convention center. I certainly don't miss that, and I'm sure you all are very happy to have that behind you. Take the first step in your careers by attending the COE today. Our first speaker this morning is going to talk about wills, trusts, and estates. He's going to talk about estate planning. And for many of us, estate planning or business organization or business succession is something that's going to touch on each of our practices, whether we actually practice estate planning or not. If we engage in any sort of transactional practice, obviously this is very relevant to you. If you engage in litigation, this is very relevant to you. If you obtain an award in litigation, usually there are some estate planning consequences to that award. And we want to consult an expert like our first speaker, Tom Jamerson. Mr. Jamerson practices with Carroll Blanton Ferris. He is a second career attorney. He started his career after graduating from Virginia Commonwealth University here in Richmond in business, and had a very successful business career for a number of years before returning for his legal education at the University of Virginia. He was an attorney with the Hunt & Williams law firm for a number of years in Richmond before joining Carroll Blanton Ferris, where his practice focuses on estate planning, business organization, business succession, and other creditor and debtor rights issues. Please join me in welcoming Mr. Jamerson.
Thank you. And let me be one of the first to welcome each of you to the Virginia Bar. As we all know, we've got, when we're members of the bar here, we have big shoes to fill. Thomas Jefferson, James Madison, Patrick Henry, of course, we're all Virginia lawyers. And remind myself of that when I think I'm failing. It's hard to fill shoes quite so big, but again, I welcome each of you. And I just learned, I thought you'd all already been sworn in, but I guess you get sworn in tomorrow, so that'll be fun. Hopefully each of your family members will come down and cheer you on. As I'm going to follow up a little bit on what Mary said earlier about general practice. I actually enjoy estate planning. As you just heard, that's not how I started my career. I started in business and then went to law school and did other things before switching over to estate planning. But what I like about estate planning, it's a comprehensive process where you really help your clients understand, what they own, how they own it, how it acts for them at different stages of life, of course, while they're healthy, full capacity, if there's any period of incapacity, and then, of course, at death, how those things pass. And you really get to sit down with clients and, handhold it sometimes and help them face specific questions that they might want to avoid. Some people like to avoid doing a will or trust or any sort of estate planning for any number of reasons. Some people are superstitious about it. Other people just don't want to face it. But you get to sit down with them, look eye to eye with actual clients, and help them face some issues, maybe family issues, maybe personal issues that they might not want to face with anybody else. And that's one of the fun things about being a lawyer. And as you heard, I began my career not in estate planning. I actually began my career in Mississippi. My first law job was in Jackson, Mississippi. I was a commercial litigator. And then I moved back to Virginia, joined Hunt & Williams in the bankruptcy group. And you might think, well, those are interesting. That's an interesting way to start an estate planning career. But estate planning really focuses or really covers a lot of topics in my commercial litigation and bankruptcy help as a foundation to step over into estate planning, because this practice covers property, creditors' rights, incapacity issues, elder law issues, which we're all going to hear more and more about as we move forward. Family law, bankruptcy, all sorts of different issues are encompassed in estate planning. And so this is what you're going to get. Of course, this is only 45 minutes today, so it's going to be a very, very high level, 50,000 foot level here. Not I'm not going to get too much into the details on each of these, but I encourage if anybody has any questions or if you're at all interested in getting into estate planning at some time as your career practice of choice, please reach out to me either by phone or by email. I'll be more than happy to talk to you. So again, when you sit down and you talk with clients, a lot of times you're going to talk, meet with somebody who really doesn't have any idea of what's going on, or the idea that they might have, might be off the rails a little bit. So first, I like to start with, when I talk to clients, I like to explain to them what it means to have no plan, to have no plan at all. And that's going to be what most of your clients do. Well over half of the adults in the United States have no plan, or of course the plan that they might have, they don't really understand what that is. So you can start with them, and explain what it means to have no plan. So we talk about intestate succession with no plan. You die owning assets in your own name. We open, and you don't have any will that directs it anywhere, any trust, any other beneficiary designation, anything direct your assets any particular place. We open up the statute and we look, where do your assets go? Well, some people, or at least I'd probably say most people, don't like to face that particular issue right off the bat, because you're essentially telling them, as an American, as a citizen, as a Virginian, you have all the power to decide what happens to your assets, and you've essentially ceded that power to the state legislature, which most people, their eyes will open up a little bit, and they didn't realize that. And we'll look at the intestate succession statute. If you're married, even if you're separated, assets might go to that spouse who doesn't live with you anymore. And it might be all your assets, depending on what those are. If you've been married before and you have children with a prior marriage, it's going to be a split between that. Some will go to your present spouse, some will go to your children from a prior marriage. That also is an issue that a lot of people don't realize, and sometimes second spouses don't realize. People are pretty savvy that they at least know that you cannot, one person that you cannot completely disinherit unless they agree to it with a prenuptial or postnuptial agreement is a spouse, but sometimes they don't realize that they're going to have to share those assets, with children from a former marriage. So again, that's a way to just start the conversation with people. Do you understand what you have? Do you understand, at your death, where it goes? Do you understand it in incapacity? Who can step in and take over and make decisions for you? So most people don't want to have no plan, so they'll come in with the idea that what I want is a will. I always want a simple will because I don't have much, and I've got a pretty simple estate, or I don't have an estate. So I want to talk about will-based planning. Of course, will-based planning is a step above doing nothing, because at least you have a document that expresses your wishes. Upon my death, I want this asset to go here, I want this asset to go here, and maybe I want to disinherit these particular people. So it is at least a document that states that. But here's this gets a lot of people in trouble with will-based planning. They don't understand that the will, or the probate system in general, will only control those assets that you own in your own name with no beneficiary designation. So I'll say that again. There's two pretty simple elements, but it gets a lot of people in trouble. The will only control those assets that you own in your own name with no beneficiary designation. So what does that mean for most people? Well, for most married couples, for the first to die, that almost means nothing. Because most married couples, their assets that they own jointly. And again, I say for most couples, I'm painting with a little bit of a broad brush here. There are obviously exclusions from this. But with most married couples, they own assets jointly. And that includes second marriages. So at the death of the first, even if so we'll just assume that, I always pick on husband, so the husband dies first, assuming that all the assets that he owned are either jointly owned or has some sort of beneficiary designation. Well, typically that joint ownership is with the wife. And so with a joint owned asset, both, as you remember from property law, now it seems like a long time ago, both joint owners own the whole. There's not a divisible interest in a joint ownership. And with husbands and wives, we call that tenants by the entirety. So when one dies, the other one just springs to ownership. It doesn't matter what his will says. What his will says, my interest in the house goes to my children, interest in the house goes to my Brazilian supermodel girlfriend, whatever it might say, it's ignored. That deed, the deed that they own the house together, that will say that it's husband and wife together, the wife is still alive, so she springs to ownership. And this is where a lot of people get into trouble. Because if you stop somebody on the street and ask them, and I don't encourage that you do this because you'll think you're crazy, but if you stop people on the street and ask them, do you think your will controls your assets at your death? Most people are going to say yes. Because most people who don't have legal training, and maybe even some people who do have legal training, their exposure to will might be through popular media, movies, or television shows or something like that. And people are going to say, well, of course my will control. What's the will for if it's not to control those assets at my death? But remember, as I just said, it only controls those assets in your own name with no beneficiary designation. So we get a lot of second marriages who only have wills, only have will-based planning, that have the unintended effect of disinheriting their children from a prior marriage. And that includes, assets like a home and other real estate. But a lot of times, and people, this is where we get into really comprehensive estate planning with people. A lot of times that also includes much more valuable assets, such as business interests. I've talked to a number of family members from a first marriage, children from a first marriage, who have been disinherited from dad's business because he only had will-based planning, or he might have had no planning at all, and at his death, all that interest flowed to the surviving wife. So again, it's important, and this is what I really like about estate planning, which I'm not saying I didn't like commercial litigation, and I'm not saying that I didn't like practicing bankruptcy in a large firm, but our clients at those two large firms that I worked with were large, typically large corporations, or certainly, bigger clients than just the individual and the small business owner. So you can really sit down directly across the table from your actual client and not your client's inside counsel representative. You can sit down with your client and you can become his attorney, her attorney. You can sit down, look them in the eye, and help them face those decisions and those facts that they have, up till meeting with you, have wanted to avoid or not thought about for any number of reasons. So again, that will-based plan, it only controls those assets that you own in your own name with no beneficiary designation. And as I said, one of those people who you cannot completely disinherit is that spouse. So we get into with a lot of clients, prenuptial, or sometimes not as often, but sometimes postnuptial planning, where again a lot of people don't want to start a marriage with talking about, well, what's going to happen if we split up, or what will happen, even hopefully much longer from now, what will happen when one of us dies. But it is important to face those decisions, and it's important to really get your clients focused on those decisions, because it does affect everything. Because if you've tried, or somebody, a client has tried to disinherit a spouse, of course that surviving spouse has that elective share option, where they can take, depending on different issues, whether there's children from prior marriages, all of those things, from a third to a half of that person's, the value of the person's estate once he dies. And we, of course, represent a lot of clients on that end. the spouse who has been disinherited, or at least the attempt was to make that person disinherited. I met with a client, I guess this was about a couple months ago now, who was, it was a second marriage, and her husband had died, and she was, oddly enough, she was the one who kept trying to get him in to do estate planning. And he had the bulk of the assets. And he always resisted that. For whatever reason, I never met him. He just resisted it. And then he died. So, about 3 months ago, about a month before I met with her. So she came in. And she said that he always said, we're a blended family. We don't need to do estate planning. And that's the exact opposite way of looking at that. He was a blended family. He should have gotten some advice. Because at least from some of his letters and some things that have come out, it looks like he did not intend to disinherit his children, but by having no plan, that's effectively what he did. So again, you get to meet with clients at a lot of different stages, and you get to sit down and really get an idea of what they really want to effectuate, and you get to help them do that. So, as I said, that will-based plan is assets, only controls those assets you own in your own name with no beneficiary designation. So we've talked about that joint ownership. Beneficiary designation. Well, we've all seen those. That's your life insurance, bank accounts, any sort of other accounts, investment accounts, those sorts of things. Where on the account or that insurance policy itself, it states, upon my death, I want this asset to transfer directly to somebody. So, at my death, I want this life insurance proceeds to go to my wife, or I want this bank account to go to my son and daughter, Happy, something like that. It goes directly to them. Now, some people like to do that because they hear from, again, maybe from other lawyers, certainly from lay people, that what they want to do is avoid the probate system. Avoid that public process, that probate system, which manages that will estate after somebody dies. Well, when you've got something that goes outside of the probate system, joint ownership or beneficiary designation, obviously you've avoided probate. But I always counsel clients, why do you want to avoid probate? And they'll say, well, I want to avoid the public system because I want to avoid the probate tax. Well, in Virginia, the probate tax is actually pretty low. So it could be a goal, but for a goal in and of itself, it might not be the best way to do it. Or it might not be your only goal that you want to do. Because again, what you're doing with beneficiary designation, by naming somebody directly, is it's going to go directly to them, avoid the probate system. But you might be causing a problem with that person's estate plan down the road. Or with their situation as it stands today. I'll give you a couple examples of that. So you have beneficiary designation at your death goes directly to somebody. Well, I've got a client, and this doesn't affect her so much, although it has a tangential effect, but it affects her brother much more. My client, she and her husband are doing fine. They don't have to rely on the public system at all. But her brother is on Medicaid. Medicaid is a system where you essentially have to be a pauper to be eligible for it. You have to have assets of less than $2,000 to be eligible for Medicaid. Well, my client's mother died and left my client and her brother, essentially half of her assets. She didn't have any plan, went through intestate succession. So with my client, it wasn't that big a deal. We're dealing with that in her comprehensive estate plan. But her brother was on Medicaid. So she left half the real estate and then half of all those beneficiary designated plans, life insurance and all that, to each of her children. Well, her brother is on Medicaid. And now it is in his estate. Now he owns it. And now he is going to have to be kicked off of the Medicaid program because the comprehensive plan that their mother didn't do at all, so she had no advice, no planning, has now affected his plan in a way that he's going to have to get off. She didn't, and it wasn't like she left millions and millions of dollars where, at least he could have lived off of it. It was only, a few tens of thousands of dollars, where he might be able to live off of it for a few months, but he's going to have to then reapply for that system. So again, that comprehensive plan about what you want to do, because you really want to ask your client, do they really understand what that plan is, what they're wanting to do? Yes, avoid probate, but are they affecting other people down the road? Virginia, to make it helpful in some ways, but also to complicate it in other ways, Virginia has recently passed in last session and became law this past July, where we can now, on a deed, do a beneficiary designation. That was something that you used to not be able to do. That was one of those few things that at your death you might own in your own name, because at your death you might still have life insurance, bank accounts, whatever, with beneficiary designation. But you had real estate, your home or whatever, where it would pass through that probate system. But now in Virginia, we can do a beneficiary designation on the deed itself. So you completely avoid probate. And a lot of people, again, come with the, I don't want to call it the misconception, but not the completely correct idea of why they want to avoid probate. So now they say, well, now I can just designate on the deed itself that I want this asset to go specifically to somebody to avoid probate. That just, again, as I said, that just causes other issues because they don't understand the comprehensive nature of that. So with estate planning, usually what we will get into the conversation with clients about is that much more comprehensive estate planning tool called the Revocable Living Trust. Now that does not mean that the Revocable Living Trust is the best thing for everybody. It does not mean that we are trust salesmen and we're trying to just get people through the door so we can do a trust plan for somebody. That's not the goal at all. We want to sit down and give people the best advice for their specific situation. But for people with comprehensive estates, business owners, people with a certain amount of assets, those sorts of things, or people with specific issues in their family. They've got a son who's a drug addict. They've got a daughter who is on public assistance like Medicaid or Social Security disability or something like that. Or they've got a special needs, somebody in their family who has special needs, some sort of handicap or mental retardation or something like that. That's when we really, that's when sort of we like to say that when it really, the rubber meets the road on estate planning, because you want to understand it, you want to dig down about what that person really wants to affect and really guide them through what they might want to affect because they don't know what all their options are. Estate planning, there's a lot of choices, there's a lot of options within those choices. So with trust-based planning, with a revocable living trust, which is essentially governed under the Uniform Trust Code, that's when you really can get with somebody and really tie all of those aspects of estate planning together. Trust will take the best aspects of your beneficiary transfer, that will-based planning, joint ownership, your co-ownership, tenants in common with other people, and really help somebody understand what they have and all the different options that they have to pass those sorts of things. Because again, most clients are going to come to you not with a real clear, some do, but most will come with not a clear idea of really even where they stand, much less about where they want to go. And so you can help guide them through that. And the trust, that revocable living trust, is a document. It's a contract, enforceable here in Virginia as well as every other state, much more easily enforceable than a will is between states. It is really a contract with themselves and between themselves, or with husbands and wives, between everybody. It's a document that says, here's what we have at this stage. It can be added to with assets. It can certainly be changed. That contractual document can be changed, thus the nature of a revocable living trust. It can be changed at any time, and it can change based on how your family changes as well. Just help them identify that. So we've got 3 children, 2 are doing fine, they've got good marriages, good careers, so on and so forth. But this particular child has always had some problems. He's never been able to hold a job. He has substance abuse problems. He's got friends who've always taken advantage of him. Those sorts of things. So that's the type of person that your client does not want to leave to directly, either in a will where it will just pass to that person directly, or in a beneficiary designation, or pass it to that person directly, where, as I said before, they might jeopardize some government benefits if they have them, or if there's somebody who just cannot manage their life very well, are not going to be able to manage that asset very well. So they can pass to them in a way that helps your client's conscience, as well as passes in a way that the person is going to have somebody else taking care of that asset as they move forward. Because clients, again, will come to you in any number of ways and say, well, we've got 3 children, and those are the 3 children I just described, and we don't want to disinherit Johnny, but we know we can't leave everything to him, so we're going to leave everything to the other 2, but they know part of that share is for their brother. Get that all the time. Clients coming in saying that sort of thing. Well, they've created a lot of problems for, they've got to trust that their other children are going to manage that well, and their children may manage that well, but what happens if, or what's going to happen to that asset if something happens to the other child who's been left with? Well, that's in his or her estate, so it's not necessarily going to get down to the son that you wanted to leave it to. So again, comprehensive, helping somebody manage that in a comprehensive way. There, of course, are many other types of trust. So we just talked about the revocable living trust. There are irrevocable trusts, and that is elder law, and I would encourage anybody, if you have any interest in working with clients who are more seasoned or more mature or whatever we're saying today, the elderly, that is where everything is growing and everything is moving towards in estate planning. Because of the aging population, if you get into a situation, if you're going to a larger firm, you can't always, or you can almost never, you pick and choose what you're going to be assigned. But if you ever get the opportunity to work on any elder law issues, certainly try to go out of your way to volunteer if you've got time to do some of those, to take on those sorts of projects. And if you're at a smaller firm, seek those out, because that's where the growth in this area is. So with an irrevocable trust, Medicaid asset planning trust, or special needs planning trust, that's a way where clients can protect assets. They can put assets away where it's still for their benefit. They lose some control, and there's some issues there. You always want to advise the client directly and correctly on that. But they can control those assets, and they can protect those assets in a way that if in the future, if they become eligible for Medicaid, or if they become a special need, individual who has special needs, then those assets are still there for their benefit, and that Medicaid or Social Security or other creditors can't reach in and to get It's, as I said, a growing area, and go out of your way if you get an opportunity and if you're at all interested to volunteer for some of those. So I've talked about essentially assets up to this point. You know, those assets that you own and what happens to those assets at death. As I said, with doing nothing, you're essentially leaving yourself up to the mercy of the statute and the legislature. Will-based planning is better than that, but it is a plan that only controls those assets you own in your own name with no beneficiary designation. The more comprehensive trust planning is a way to bring all of those together in a way that gets clients to the goals that they want in a much better way. But what a lot of people forget about when they talk about estate planning is incapacity planning. I actually think estate planning is misnamed. When people ask me what I do, I say I'm an estate planning lawyer. 90% of the time, people say, well, I don't have an estate, so there's no reason for me to even talk to you. Well, everybody has an estate. The estate starts with you. So I haven't come up with a better name for the practice area. But it starts with you. And because we say estate planning, and a lot of people say, well, I don't have an estate, or at least they think they don't have an estate. What they forget about is incapacity planning. Here in Virginia, as well as every other state, we've got the public system of guardianship and conservatorship. If somebody becomes incapacitated, so they are unable to make the decisions or understand how to manage their own assets and financial affairs, or they're unable to understand the nature of a health care need and evaluate any plan or evaluate the alternative plans regarding their own care, well, of course, they're incapacitated. And we do have the public process of guardianship and conservatorship. That's where somebody will sue an individual and allege, just like any lawsuit, in the complaint, they will allege, or the petition, they will allege that that person is incapacitated, they're unable to manage their own affairs, unable to care for themselves, and ask to be appointed the guardian or the conservator. Guardian, of course, have control over the person, so health care decisions, where they're going to be, where they're going to live, how they're going to be cared for, those sorts of things. And conservator over their assets. Typically, it is almost always in one action where you ask to be a guardian and conservator. Sometimes you have one action, but you have two different people asking to be, one be the guardian, one conservator, but usually it's one person who asks for both. Public process. It is expensive and it is time consuming, and like any lawsuit, it's in open court. Again, most people don't take the time to do the simple steps to avoid that. To have a power of attorney, I'm not going to say it's a simple document, because it can be a simple document. It's better, it's a little more complex than just simple. But it is a document that says, if I become incapacitated, you can define your own incapacity right on that document. I want this person to step up, or these people to step up, and be able to make those financial decisions for me. Manage my real estate, manage my bank accounts, deal with government agencies, Medicare, Social Security, deal with former employers regarding benefits or pension plans or anything like that. So that's regarding your asset decisions. Or the advanced medical directive, where you will name a medical agent to make decisions for you, again, if you become incapacitated. Make decisions from the mundane, to be able to be taken to my regular checkups, regular doctor's appointments, dental appointments, those sort of things. Or through the very serious. Get a serious accident, a serious illness. Who's going to care for me? Where am I going to be cared for? How am I going to be cared for? Those sorts of things. Those documents themselves, with the lawyer sitting down, depending on the lawyer, it's going to cost, maybe a couple $100. The process of guardianship and conservatorship is certainly not just a couple $100. It's probably going to be at least a few $1,000s and take a long time to get there. And if it's a contested matter, well, then that's obviously even more expensive and more time consuming. Example there, we just had a trial on this back in June, so just a few months ago, where we had an individual. He was remarried, he had Alzheimer's. He was with his third wife, and his daughter from his first marriage, and she was the one that we represented, wanted to be his caretaker, both his conservator and guardian. And of course, the wife wanted to be his caretaker, conservator and guardian. So we initiated the action to be named that for our client. He had never written down on any document about who he really wanted to care for him. So I think they both could truthfully testify that he had told the wife, when he was with the wife, I want you to take care of me. The daughter, when he was with her, I want you to take care of me. So they're both testifying. The entire case lasted about a year and a half from initiation of the action through all the discovery, through the actual trial. The trial lasted a full day, 9 in the morning to 8:30 at night. So our bill alone was over $30,000. The other side, we didn't see that bill, but it's probably about the same. So for a few $100s, he could have just had on a document, on a power of attorney, on his advanced medical directive, I want these people to be able to make these decisions for me. So that's a real world example of somebody just for whatever reason avoiding the hard decisions and then leaving an issue, leaving a problem for somebody to take care of on the back end. So even if you're talking to a client and they can't make that decision, oh, I want a will, I want a trust, whatever, you can at least say, you need these fundamental documents. Some lawyers will call these ancillary documents, the power of attorney and advanced medical directive. I think that gives them too little, that doesn't give them their full due. I call them necessary or fundamental documents, that power of attorney document and the advanced medical directive. Everybody needs them. And here, the old look to your right, look to your left, I guarantee you most people in here don't have these either. So that's your first homework assignment after you get sworn in tomorrow. Is go, meet with somebody, sit down, and get those documents in place. Just because you're young, just because you're healthy, doesn't mean something won't happen to you. You want somebody to be able to step in, to be able to make decisions for you in the least expensive and least time-consuming way. They can just step in and be able to manage your affairs. So I think we're coming near the end here. I don't know how much. I think we started a little late. So I'm going to end to talking about representation with the husband and wife client. And you probably went over this in your ethics class. When we meet with clients, it is very important to make them understand who the client is and who your representation flows to, who that duty flows to. Because with spouses, not all the time, sometimes we will represent one of the spouses and not the other, but typically we will represent both spouses. And it is very important, and actually under our rules of professional responsibility, we have to let them know, we have to acknowledge this to them, that we represent both the husband and the wife. Because we don't want one coming to us later on and say, oh, by the way, I'm having an affair and I want to leave some of my assets to this other person. And I have not had that happen to me yet, but I have had colleagues who said that that's happened to them. So it's very important for us as lawyers to be very upfront, saying, both husband and wife, we are meeting with both of you. We represent both of you. And so it's important for you to understand that anything one of you brings to us has to be shared with the other. You cannot keep any secrets between you. The beneficiaries, of course, always think that they are part of the representation as well. And I've included in your packet a case regarding, it's a very, very helpful case for Virginia lawyers practicing here. And as far as I know, it's the only state where the duty of loyalty and the duty of care does not flow to the beneficiaries. It starts and ends with the client itself. So if a beneficiary sues a lawyer saying that, or alleging that certain things weren't done, certain things weren't alleged, certain things weren't divulged, whatever, the beneficiary does not have the protection that they do in other states. It's very helpful for Virginia practitioners. So I think I'm right at time. Is that about right? Yes, I'm right at time. So if anybody, maybe I'll open it up for one question. Do I have time for one question?
Yeah, I think that sounds great. First, let's give Thomas a round of applause. Thank you. And we do have a few minutes. Does anybody have any questions about an estate practice or wills or trusts or certainly elder law issues, which I'm glad that you touched on? That is a rapidly growing area of law here in the Commonwealth of Virginia. It is certainly something you should consider when you're entering your practice. Are there any questions for?
Yes.
Is there any, like with elderly people, they often have these really important documents and then they misplace them. And then sometimes their spouse doesn't know, whatever has happened. So is there any like state filing system that can hopefully, I don't know, help that, or filing with a lawyer or something like that?
Yeah, the question is when a client has important documents, whether and they can't find them, is there a state repository for you? Things like the, I'm assuming you asked like the power of attorney, the advanced medical directive, those sorts of things. There have been some suggestions regarding that. Right now, there's not really a good repository for those. And the problem, one problem with those is people, even if they file with something with a repository and they make changes, they might have forgotten. So so which document controls? Of course, it's typically always the most recent document is going to control. We give very detailed instructions with the clients about where to keep things like that. Some clients don't have a problem, giving, and they've got very good relationship with their children. If their children are the beneficiary, they'll go on and give a copy, and they'll give detailed instructions about where to get, where they're storing those with the beneficiary. Some people don't trust their beneficiary, don't trust their children, so that's not a good way. And it just, I advise, it depends on the client. I have advised a client who didn't trust any of his children. He said, well, even though he named the children on a couple of the documents as decision makers, but he didn't trust them not to go in and make some changes. So I couldn't convince him to change his mind on that. But on that particular client, I advised him, do you have a trusted friend, even somebody you haven't named as beneficiary, or your executor or your trustee or anything, but you have a trusted friend, keep them with him. Your children don't have access to that. But somebody does need to know where you keep those originals. And that's all, that is an issue because, and I hate when a client leaves my office, I always hate, and this is all, so I try to make follow-up meetings within a couple months to keep everything on the front burner. I hate for somebody to leave and just take this document home, and just put them on a shelf because they think they've done it. The documents are just the expression of what we've done. This is a continuing relationship that you want to have with your client, but it's a continuing relationship you want your client to have with his or her own plan. So it's always, that's a good question that always doesn't have a great answer.
Well, thank you so much, Mr. Jamerson. Thank you again.